Any mention?
May it please, Your Lordship?
Yes.
Lordship, I beg to mention item number 9. Lordship, I paid for 2 weeks' time.
Yes.
Yes, I'm for a petition.
What is this? Service matter?
This is regarding service matter. I was suspended and I was kept there. For,
District Council.
not district council. It is a municipal, Bakmara municipal.
Your challenge is against suspension order.
Again suspension. They have yes.
So,
Since it's taking time, so I don't want to work.
how much time?
2 weeks, Your Lordship.
You're there? Yes. You're appearing for response number?
3 to 5, Your Lordship.
Preempted by MS Dakhar. Yes. Appearing for response number 3 to 5. Not objected to by the counsel of the petitioner. List after 2 weeks. Yes.
Please, Lordship. It's item number 16, Your Lordship. I'm for the petitioner. I've informed to the private respondent also, challenging the author of this. I'm taking time, Your Lordship, beg to mention this. Maybe let this matter may come after 2 weeks, my Lord.
No objection, Lordship.
Preempted by list after 2 weeks. Yes.
Much less, Lordship.
May it please, Your Lordship?
Yes.
Lordship, I beg to mention item number 11 and 12, Your Lordship.
Yes.
No objections, my lord.
What is this matter? Quashing.
Yes, ma'am.
This is a revision application.
What is it? My lords, I don't have the file with me, my lords. I'm sorry. The conducting counsel is Mr. Argo.
How much time you need?
2 weeks, Your Lordship.
11 to 12 on the prayer of the petitioner. Yes.
11 and 12 are connected, right? Lordship, 11 and 12 are connected. Wait for.
See, brother.
Item number 15, my lord,
Yes.
making a joint mention, 2 weeks.
What is this about, Mr.
This is
Gautam?
an application for quashing of, my lord, CR case under the Drugs and Cosmetics Act.
This cannot be settled.
I'm sorry, my
These
lord.
matters cannot be settled.
No, my lord, cannot be settled.
Okay. On joint preliminary with the parties. List after 2 weeks. Sorry.
Obliged.
All right, Lordship.
Lordship, I beg to mention item number 22, Lordship, for the respondent. Mr. Pandit is there. I'm praying for 2 weeks' time, my Lord, to complete my instruction, my Lord,
This what? This is also quashing.
for quashing of a rash and negligent case. My Lord.
Compromise, on the basis of compromise.
There's
Yes,
a compromise, but I am to complete my instructions.
This is also preliminary by Mr. Sengupta. Learned Council. Mrs. Mehta after 2 weeks.
After 2 weeks.
Yes.
Highly.
May it please, Your Lordship. Lordship, I
Yes.
beg to make a mention for item 14. Lordship, we've just received the charge sheet today, Your Lordship. So I'm praying that the matter may come up after 2 weeks, Your Lordship.
Chart sheet.
Lordship.
So what is under challenge in this petition?
Lordship, 482, Your Lordship. This is 482 application, Your Lordship.
Could not follow.
This is a 482 application, Your Lordship.
It's okay, but then you are challenging what? FIR.
Yes, Lordship, the entire proceeding, Lordship. The entire proceeding, Lordship, and the FIR.
Entire proceeding.
Lordship.
But the time when you filed it, there was no chart sheet. It was chart sheet came later or?
Yes, Lordship.
No objection.
No objection.
Here for the private respondent.
Yes, 3 and 4.
Okay. 23 was the prayer of the petitioner. How much?
2
time?
weeks, Your Lordship.
2 weeks. Yes.
Highly obliged, Your Lordship.
Please, Your Lordship.
Yes.
Your Lordship, I beg to make a mention of item number 20, Your Lordship. Your Lordship, I humbly pray for 2 weeks' time in this matter as the conducting counsel is out of station, Your Lordship.
You're applying for the appellant.
Yes, Your Lordship.
Who is for the state here?
Mr.
Item
Harmi.
Yes, Mr. Sangupta.
No objection, my Lord.
20 on preliminary by appellant. List after 2 weeks. Yes.
Highly obliged, Your Lordship.
Please, Your Lordship. Lordship, I beg to mention item number 19, my Lord. I've
Yes.
taken the consent of the other side. This matter may kindly be taken up next week, my Lord, subject to Your Lordship's convenience.
My lord, I'm appearing for a state. I have no objections.
No objection, Your Lordship.
This is also quashing,
For quashing.
domestic violence.
Lordship, he agrees
Arises from a matrimonial
Matrimonial.
disputes, my lord.
dispute.
No settlement.
Settlement, actually, the husband is not participating in this case, neither before this honorable court nor before the trial court. my lord.
In the proceeding, he has not appeared.
He is not appearing anymore. It is said that he is absconding, my lord. Even before this honorable court, he has not entered appearance.
So then, what you are challenging in this criminal
In this,
petition?
we are challenging two orders, my lord. One is an order passed by
Passed by
the
trial
court,
court.
from the trial court, my lord, directing investigation to be transferred to Muzaffarpur, Bihar, on the ground that the cause of action arose there for quashing of that order.
Okay. This is also 2 weeks. 2 weeks.
All right,
Yes,
2 weeks.
from the prayer of the petition. Yes.
Much obliged.
Lordship, I beg to mention item number 21
Yes.
for 2 weeks, Your Lordship. This is a quashing petition, POXO.
It is related to that matter pending in division bench? No. Is it?
Yes.
Then you take 3 weeks if it is dependent on the outcome of the division bench matter.
This is a joint petition by both the accused and the petitioner, since they are living as husband and wife.
That is the thing.
This also, to make it 3 weeks. 21 on the prayer. Please. Come up for 3 weeks.
Yes. May I please, Your Lordship?
Yes.
Beg to mention item number 10, Your Lordship. I pray for 2 weeks' time, Your Lordship. Yes, Your Lordship. No objection.
Prayer of the petitioner, not objected to by the General Counsel for the respondent. Is after 2 weeks. Yes.
Highly obliged, Your Lordship. Much obliged, Your Lordship.
May it please Your Lordship, I beg to mention item number 18.
Yes.
Your Lordship, I need 2 weeks' time.
You are appearing for?
Respondent number 2.
I'm for the petitioner, my lord.
Any objection?
No objection, my lord.
On prayer note, on behalf of the respondent, number 2, list after 2 weeks. Yes.
Much obliged, Your Lord.
Highly obliged.
Lordship, I may be allowed to mention item number 13, 1-3, my lord.
Yes.
And the petitioner in this matter. Some slight difficulty today, my lord. If this matter can come up next week, my lord.
Next week may be a bit difficult.
Whatever's convenient.
After 2 weeks.
Very well.
No objections, Lordship.
One request by Mr. Jindal, General Counsel appearing with the petition, list after 2 weeks. Yes.
Much obliged.
Please, Lordship. Lordship, I beg to mention item number 17, Lordship.
Yes.
Lordship,
17 you are appearing for the
respondent number 2, Lordship. Lordship, here I have filed for substitution in the criminal proceeding to substitute me, Lordship. In 482, quashing of the FI, Lordship.
Lordship, in this we will file the objection, Your Lordship.
that application is pending. It has not been allowed. Substitution application?
No, Lordship, the petition is filed, so now they are supposed to file objection, but the matter is listed for hearing, Lordship. We have a bar meeting, Lordship, at 12 o'clock, Lordship. So.
No, that is all right. But then the thing is that without deciding the miscase fast, we cannot go.
Lordship, no. The Lordship, my petition of substitution is still pending, Lordship.
So that is, has any objection been filed there?
No, Lordship.
We'll be filing it, my lord. We have sent the draft to the petitioner.
Okay.
So we'll be filing it before the next date. my lord.
Until and unless we decide the miscase
Yes,
fast.
yes,
then we
exactly.
cannot. Yes, then why is the mention over? You should have.
Then Lordship, okay, Lordship, that matter be called out. Because I was under impression. I asked him. He told me that he will be doing the hearing. It was
No, but
Anyway,
I have nothing to say.
Just allow the matter to be called. Just allow.
My lord.
Just
Yes.
speak with you, Mr.
That is why we have not made a mention.
Okay. Yes.
Don't put your word in.
Yes, please call.
Supplementary causeless, item number 1.
My lord, pertaining to this, Mr. Yobin is the conducting counsel and he's indisposed today.
So what is to be done?
Supplementary.
What is
On Monday, if it's allowed.
what is this matter?
This is regarding the
for-
seniority matter.
Is there any prayer for interim relief here?
No, my lord.
Seniority list.
Oh, that is with regard to seniority.
Seniority, my lord. My name was not included even if after serving for 35
Private
plus years.
respondents are there. Lordship can issue notice only for the purpose of notice. State can receive notice in there. Private respondents are there.
15 private respondents.
Okay, that is if notice is this thing, then you can.
These 15 private respondents, my lord, are my juniors who are much more junior to me in the seniority list. And their name has been reflected.
How many private respondents are there?
15, my lord. 1-5.
Then halt, Mister.
Page 39, my lord, to 47 is the names.
1-2.
Sorry. Page
There is
52,
a-
my lord.
Oh, this is second round of litigation.
No, it's for motion, my lord.
No, earlier also there. was a-
Earlier it was there.
Oh, this cannot be taken up by this bench, Mister. See page 35.
Yes, my lord. My lord was the counsel that.
Should have pointed out. List this
sorry,
matter
my
before
lord.
any other bench. Yes.
Item number 3.
Oblige me.
May it please your lordship.
Yes.
Last three items of the supplementary list are connected, my lord. Arising out of a common judgment dated 31st July 2025, an order of sentence dated 1st August 2025. I have been convicted by the Court of Sessions under 40304 Part 2 and sentenced to 5 years of imprisonment. My lord, the appeal is within limitation. And my lord, I pray the appeal be admitted today. My lord, the only prayer as of today is, my lord, FIR was filed in the year 1997. My lord, charge was framed sometime in 2008-2009. Trial commenced in 2016. And thereafter, my lord, 2005, these people were convicted. Well, all of them are 70 years old. Well, out of that, my lord, criminal appeal number 63, which will be item number 5 in today's cause list, my lord.
Yes.
The appellant, my lord, is suffering from a very serious ailment, my lord. He gets seizures. So, along with all the 3 criminal appeals, my lord, I have also filed application for suspension of sentence. My lord, of course, on merits, my lord, my case is, my lord, in this case, what has happened? Before a trial commences, a charge has to be formally framed. No charge was framed. In fact, there is only an order sheet which says that charge was framed. And my lord, the trial court has recorded that in the judgment also. The trial court has come to a finding that even though charge is not framed, the people participated in the trial and they knew that they were tried for a particular offence. Well, of course, that is something which I'll argue on merit. Apart from that, my lord, the entire conviction is on the basis of a confessional statement made by them. Confessional statement is made within 24 hours of arrest. Now, my lord, the records does not even actually suggest whether they were in police custody or were taken out of police custody and thereafter sent to judicial custody.
But then it was after arrest.
Just after the arrest. So, when normally within 24 hours, a person who is arrested is brought before the magistrate, and thereafter, my lord, if a prayer is made for recording of confessional statement, sufficient time is given, and then, of course, my lord, those arguments will be on merit after I prepare the paperwork. Well, as on today, my lord, my only prayer before this court is, my lord, taking into consideration the age of these people, especially, my lord, criminal appeal number 63, my lord, this person is suffering from a serious illness. This is what I have been told. So, my lord, if we can at least have a medical report, my lord, and then, my lord, maybe I can argue to at least, my lord, to get this person out on bail.
We'll admit this, the call for the
Yes, my lord.
response.
Yes, my lord. And in the meantime, my lord, only thing, my lord, if the miscase can be fixed, my lord, if a shorter date.
You are seeking bail on medical ground,
my lord.
then onus is on you to first.
Absolutely, absolutely. But
So your petition is supported by any medical.
no, my lord, the problem is that, my lord, since these people are in custody right now, my lord, I will not be able to bring the latest medical report. So, my lord, if a medical report is called for, my lord, because even in the jail, my lord, I have come to learn that he's suffering from seizure. He gets these fits. So it is quite a serious
Yes,
situation.
Mr. Shulai, any problem in having medical report of?
Made, this is your lordship. Lordship, only I have lordship. Admittedly, the conviction is only for a period of 5 years, lordship, and this appeal has been filed under section 415(2) of the BNSS. If lordship kindly have a look at that, your lordship, at that 415(2), your lordship.
It is not akin to 374 CRPC.
No, your lordship, under 415 of the BNSS.
No.
Lordship kindly
This is
have.
not in parameter area with.
No, your lordship. There is, if lordship kindly see, your lordship, 415(2) of the BNSS.
Yes.
Lordship kindly see any person convicted on a trial held by a session judge or an additional session judge, or on a trial held by any other court in which a sentence of imprisonment for more than 7 years has been passed against him or against any other person convicted. At the same, he may appeal to the High Court. So, your lordship, admittedly, the conviction here is only for 5 years.
It will be under this provision only. When it says or, it says or.
There
Learned senior has missed out the preposition or. Otherwise, I'll be remediless.
Lordship, revision is there.
No. What you say, Mr. Shulai, you verify it. That is the same thing.
Lordship kindly see.
Same thing.
It say.
There is a decision by Guwahati High Court by Justice Ansari in this aspect. Just read it and then it will clarify.
Because you say more than 7 years. So, if more than 7 years, your lordship, it's appealable.
It is not. The way you are interpreting it is not that.
It is not like that.
You need to segregate the sentence and then.
The preposition or has been missed out.
Then, if lordship is not.
Kindly see it. What you are saying apparently is not correct. Okay. We'll see. We'll just admit this thing and then just see in all the thing. You just say, heard Mr. Gautam, Lana Council, appearing with the appellant, admit it is appeal. Mr. Shulai, ND Shulai, along with Mr. Khaini, appears for. How many respondents are there? There is only.
Only the state.
Appears for the respondent. Mr. ND Shulai, AAG, appear along with so-and-so. Okay. Call for the LCR, lower court record, list immediately after receipt of the LCR. And in the miss case, just say list along with the main criminal repeal, the interim prayer to be considered after receipt of record. Well, now, if the third one, just after this, in the third one, this will be addition in the third appeal. What is that appeal number?
My lord, that is appeal number 63.
And what is the miss case?
Miss case will be 100.
Yes. After you write this after they will be considered these things, it is submitted by the learned counsel for the applicant. This will be in continuation of that other 2 lines. Okay. In addition to these things, observed by Mr. Gautam, learned counsel, the applicant, that the applicant has serious health issues and his detention in detention may have a serious consequence. Stop. Just in view of the submission, it is directed that. Well, there are 2 respondents, isn't it?
Well, the state respondents.
It is directed that medical report with regard to the applicant's health be filed with the state before the next.
We'll get it from the jail authorities, your lordship. Since he is in jail, we'll get it from the jail authority.
Whatever it is, you direct, you make the direction, but only asking you just to produce it. Okay, before the next stage. Stop. You have already said on the top list along with the main things, isn't it? Yes. We'll just call for the
My
report.
lord, my lord. Much obliged.
Obliged, Your Lordship. 3, 4, 5.
Item number 1.
Yes.
My lord, there was a title suit in this case. There was a title suit, my lord. That was decreed. Then there was an appeal. The appeal attained finality. Then there was a review which was filed against the...
Title suit with regard to?
My lord, it's with regard to a property for eviction.
Okay.
So they succeeded in the
So
suit.
it was the eviction suit.
Eviction suit, my lord. So then there was an appeal. The appeal also attained finality.
You are the tenant.
I am the landlord, my lord.
Okay.
I'm the landlord, they are the tenant. So then they filed a review against the judgment in the appeal, and then they have filed a
You
revision
filed the suit. The suit was decreed in your favor.
against me.
They filed an appeal.
No, the suit was decreed in their favor.
Okay.
So I filed an appeal. Then I succeeded in the appeal.
You were restrained from evicting them. Now you filed an appeal.
I succeeded in the appeal.
Yes.
After that, they filed a review against the
Okay. Order of the
judgment-
appellate court.
uh,
Review
appellate-
before the appellate
review.
court. Yes.
So they did not succeed in the review. Now they have come and challenged it in the revision.
May it please, Your Lordship. Lordship, I just seek accommodations. Let this matter may come up next week. Your Lordship, the senior conducting counsel is.
Who is senior
Mr. S. Chakraborty.
Chakraborty.
Yes.
Sir Chakraborty.
Any date, Your Lordship, next week.
Well, at previous occasion also they had seek time, but since sir is not there, he's having some personal problem, they have told.
Any interim order by this court?
Yes, my lord, they are enjoying a stay.
This eviction matter, until unless there is a stay, matter will become infructuous.
I pray the interim order, Lordship, may be continued till the next day.
Okay, next. Not possible. Okay, we'll just see. How a revision? See, second appeal lies, isn't it?
My lord, on the previous occasion also we made a submission that we are challenging the maintainability of this revision application.
But then again, one problem is that against rejection of review, no appeal lies.
My lord.
Yes.
Now it is only the order passed in the review which is under challenge. That is
My lord, but since they have come under 115, so it will be very limited.
Jurisdictional error.
Only jurisdictional error. Whether the
That is
court.
okay. If you come to the scope, that is okay. But then if you question the maintainability, then it has to be on something else.
My lord,
Anyway.
because if they have come with the matter, they will have to come within the scope, challenging the jurisdiction of the court, which exercised it while reviewing the petition. So what they have come up with some new grounds, my lord, next week it can come up. We can argue it and.
Okay. This in the revision application, just say, on prayer made by Mr. You are Mr.
Ilalu.
Pink rope. Yes.
No, Ilalu.
Ilalu.
Lordship.
On prayer by Mr. Ilalu. Seeking accommodation on the ground of unknowability of Mr. S. Chakraborty, Leonard, senior counsel, appearing for the petitioner. The matter is urgent. List after a week. And in this case, you just say list along with the main revision petition. The interim order passed earlier shall continue till the next day. I'm prepared on the next occasion. This what was the ground of review taken there?
My lord, they tried to introduce new evidence in review.
No. What was the ground taken?
My lord, the ground was that they said that this evidence.
Did they say that there was an apparent error or?
No, my lord. They haven't.
Discovery of new evidence.
My lord.
only
And
the-
what grounds they took in review is again different from the grounds they have come under.
Okay.
Lordship,
You
the
jump to
same
merit
ground
very
only we
fast.
came.
My lord.
Huh?
Lordship,
Just
the
tell
same
us the
ground
facts
only we
as
came.
it is.
My lord.
Okay. All right. Thanks.
Highly obliged.
Item number 2.
Yes.
Your Lordship, with your Lordship permission, I'd like to withdraw the matter, Your Lordship. I want to withdraw the matter, Your Lordship.
You would like to withdraw?
Your Lordship.
You're appearing for?
All respondents, Your Lordship.
Very happy.
Otherwise, we are challenging the maintainability, Your Lordship.
MSM Rahman, Learned Counsel, appearing for the petitioner on instruction submits that petitioner does not want to press his application and prays for withdrawal. Let's see.
With the liberty to approach the trial court, Your Lordship.
This is what order? What order you have challenged?
Lordship, here we have challenged the order dated 9/7/2025, Your Lordship. Whereby the matter has.
Yes, in view of the above, this revision petition stands dismissed. Stop. However, the petitioner will be at liberty to approach the appropriate court for redressal of our grievance. This is okay. All right. So you'll have the liberty to approach the appropriate forum. Yes.
Obliged, Your Lordship.
Item number 3.
My lord, the facts of this matter.
Anyone appearing from what is the
My lord, the facts of the matter. My lord, there's an FIR which was filed against me on 23/4/2025, Annexure 1, page 14. My lord.
pending for filing of objection?
My lord, it is pending for filing of objection, and I have
one number 4.
2. Yes. My lord, since filing of my petition for quashing, the matter has been surprisingly charge sheeted by the investigating officer, and I have been issued a summon. Now, I have also filed a miscase to stay the proceedings, my lord, for there not be an abuse of the process. The application.
Your challenge is what? In the main criminal petition, your challenge is?
I've challenged the FIR, my lord, quashing of the FIR.
In the meanwhile, charge sheet has been?
My lord.
Filed.
My lord.
Now you have to bring on record those charge sheets.
My lord, we'll bring on record that charge sheet as I have right now. I have filed a miscase. It's there with the record, my lord. If it sees. My lord, page 11 of my miscase.
The problem is that with the counsel appearing through VC.
My lord.
Now we cannot hear him, we cannot see him properly also.
Lords, I heartily apologize for not being able to make, but I assure my lords on the next date of hearing, my lords, I'll surely
You are appearing for respondent number?
Physically, my lord. Private respondent, my lord.
Appearing for the?
4, my lords. Respondent number 4,
Yes. Have you filed your objection?
Complainant, my lords. The respondent number 4. They have not filed as yet, my lord. My lords, I was supposed, my lords, but today, my lords, today only the charge sheet has been, my lords, filed in the court.
That
my
is
lords.
okay. Okay.
I haven't gotten the copy of the charge sheet.
Have you filed your objection?
My lords, I filed my objection. My lords,
Mr. Renja, you were there.
However, my lords, since the... Indeed, my lords, Mr. Renja is the local counsel, my lords.
Have you filed objection? Okay. So you'll be requiring some time for filing objection. Okay. You bring on record this thing.
My lord, I have 2 submissions to make. I'll make good of my case to stay the proceedings. My lord, page 11.
First, you bring this charge sheet on record.
We'll bring the charge sheet, my lord. Page 11 is the summon. Now, my lord, let me. Am I allowed to submit?
Lordship, let the matter be heard finally.
But I am being called there to appear, my lord.
Cognizance has already been taken, your lordship.
My lord, that cognizance.
If you just both of you talk together, then nothing. See, there's no problem. You see.
My lord, my whole argument today is that
what is the offence involved?
My lord, they have charge sheeted me under criminal breach of trust and cheating.
And what is the nature of allegation?
My lord, the FIR says that I had taken a loan and nothing else.
Where is the FIR?
My lord, page 14, my lord, of the main petition. If I may, my lord.
Page 14 of the
main petition, my lord. If I may, my lord.
Yes.
To the officer in charge, Tura Police Station, West Garo Hills, Tura, dated Tura the 23rd of April 2025. FIR against Shri So-and-so of Tura Bazar. With reference to the subject cited above, I have the honor to submit before your good self office that Shri So-and-so, a resident of Tura Bazar, had requested for a loan an amount of rupees 25 lakhs since he was facing a financial crisis. I, upon his request and being my neighbor and on humanitarian ground, had given him rupees 10 lakhs only in his account of SBI and rupees 8 lakhs only in his account of HDFC. The remaining 7 lakhs was only given in cash in the year 2023 month of May. Upon requesting him to return the said amount, Shri So-and-so is not responding to any of my communication and returning back the money. Therefore, sir, I humbly request you to please look into the same and help me to get back my money which was given to Shri So-and-so of Tura Bazar as a loan, for which act of kindness I shall ever pray. My lord, basic crux in the FIR is that I have taken loan. Now, loan by definition is a civil transaction, my lord. There is no say of cheating or criminal breach of trust. My lord, they are requesting the police to help recover the money in the FIR. Now, my lord, let us see the summon which has been issued to me. Miscase, my lord, page 11.
Yes.
May, my lord? My lord, to the petitioner herein, whereas your attendance is required to answer an offence under section 31824 and 3162 of BNS, you are hereby summoned to appear in my court on 12/9/2025, that is today, my lord. You may appear by pleader or may plead guilty in the offence of the said charge by registered letter with driving conduct license to reach this court before, my lord. Don't understand now, my lord. The succeeding page, annexure 2, is the order, my lord, on which this summon was issued. If I may, my lord. Order dated 37/2025. CR placed before this court on being endorsed with the file for disposal by order dated 28/8/2025 passed by the learned CGM. My lord, I feel there is some error. This order is dated 37/25 and the endorsement order is being said is of 28/8/25. Now it goes on. BA to institute the case to my file issue summons to the accused, intimate the learned PP to depute learned APP to conduct the case, fix so-and-so for SR appearance and copies. My lord, this order and the consequent summon has been passed without application of mine. Now, to support my argument, my lord, I will place a very recent judgment. In Delhi Race Course, the Apex Court has gone to say that 406 and 420 cannot exist together. Now, my lord, I am not going to argue today that it is a civil offence. I leave it to my final arguments. But as on date, the summon for the sections that has been issued to me, they have been issued without application of mine A, and so much so, my lord, that 406 and 420 cannot exist together. My lord, if I may.
See, that part we'll see later, whether these two sections can exist together or not.
My lord, the Apex Court has come very clear, not just
What is the wrong in the issuing process? Yes.
My lord, if the court had applied its mind, it would have seen what are the merits in the record, and it would have come to a conclusion that 406 and 420 cannot exist.
What is needed for a court?
My lord,
So far as the cases which come after investigation conducted by police.
my lord, the court will have to see if there is substance enough material.
The procedure, just tell us.
My lord, under 190, the court will have to, referring to the erstwhile CRPC, my lord, the court will have to apply its mind to see if there is enough material which exists against me to call me up for the trial.
Is it not enough the charge sheet is there?
My lord,
Is it not enough that there is a charge sheet?
my lord,
Is it not that the charge sheet is something like a existence of prima facie case?
my lord, in
And
that, my lord.
You have the opportunity of filing a discharge application before the court if you find that there's nothing.
My lord. My lord, I have there is a law which says that if prima facie there is no case, expecting or directing me to go for a discharge application in itself becomes bad in law
But then,
and an
see,
abuse of the process.
To decide whether there is a case or not, then we have to go for a full-fledged hearing, is it?
My lord, at this moment I am praying that since the FIR prima facie shows that there is a civil offence which exists, and I have challenged the very FIR.
You bring on record the charge sheet. You see,
my lord,
the situation changes once charge sheet is filed.
My lord.
Now FIR, the allegation of FIR is supplemented by the investigation, the outcome of investigation which is reflected in the charge sheet.
My lord.
So now we have to go through that.
My lord.
If you have to at all appreciate your submission.
My lord, for that, I'll again be placing reliance in a judgment of Joseph Salvaraj. My lord, it's a 2011 SCC citation, my lord. Over here, the court has categorically stated that even if the charge sheet has been filed, the FIR will have to be seen into to see if any prima facie case is made and it quashed the proceedings.
But there are some decisions there.
My lord.
Yes, Your Lordship.
My lord,
Let me finish,
I
Your
pray,
Lordship. Let me
I
finish.
will bring the
I'll
charge
see
sheet
it
on
all.
record.
I have
Let the
those
proceeding be
decisions.
stayed so that it's not abused. I am going under medical
Once
treatment.
we bring the charge sheet, let us see what is there. Then
My
we
lord.
prepare. First, bring on record. Okay.
My lord, I am currently my lord, I am currently undergoing a medical treatment in Delhi. I have annexed all my medical documents, so physical presence of mine is not being.
We'll take a call once you bring on record the charge sheet.
No, my lord, matter has been fixed today again. I am at Delhi under medical.
It's
No, at the court there. So, my lord, my physical presence will not be. I'll not be able to appear there because of my medical treatment which is going on, as on date. And my lord, if we.
That you take steps in trial court. Why? What you want this court to do at this stage?
My lord, I don't want the process to be abused by me being directed by the court that to appear.
You appoint a lawyer and make necessary application before the court. There is a procedure prescribed in law, isn't it?
My lord, if I can place one paragraph from the judgment I have given, my lord, to take a call, because it says that 406 and 420 cannot coexist under any circumstance.
This we'll see. We'll see at the time when you take up the matter for final disposal.
My lord.
Just right in the main case. You just
In
said-
fact, Lordship, the view taken by your Lordship, once a charge sheet has been filed, then the accused will have to go before the trial court to file this charge.
That is a
application.
recent judgment by
There
Justice
is a judgment,
Purdiwala
Your Lordship.
and all, isn't it?
I have the
Proper-
judgment
yes.
with me, Your Lordship.
My lord.
I have that judgment with me.
My lord, since April this year till last month, my lord, I think several judgments have come down with regards to civil offences being given a criminal nature and some befitting my case to the hilt.
Yes, there are a number of cases.
I have a
My
judgment,
lord.
Your Lordship.
But then, you see, if you see, there are many decisions which runs contrary to each other.
My
See,
lord,
like-
I am not going on the merits of my argument. I don't even have an account in SBI.
These are-
But my
these
lord,
are
I
all-
cannot be. I
these are
cannot
all-
be.
all- These are all matters of merit, isn't it? Whether you have account in SBI or not.
How do we know?
Let the charge sheet come.
I have a
let the
document.
charge sheet come.
I have
let
an
us
IO
see.
report annexed when I was seeking anticipatory bail.
Just hold on. Just let us see what is happening. See what is there in the
My
charge
lord,
sheet.
until then, if I am being subjected, the process is being
Do
abused
not,
against
do
me.
not expect this court to pass anything, any order in the air without seeing the materials on record. It
My
is
lord.
in your submission, the charge sheet is there. We would like to see charge sheet before we pass any effective order.
My lord, an observation to that effect may be given in my miscase in that.
What observation?
That decided charge sheet is. I'll bring it.
We'll just see this.
Yeah,
See in the main case, you just say on prayer made by Mr. Whose name shall I? Mr. Counsel appearing.
Roop Jain, madam.
Mr. Roop Jain, learned counsel, appearing for a of how much time you will be needing for filing objection? 2 weeks time is
Plus,
granted for filing objection in the matter. Okay.
deeply obliged.
List accordingly and come to this case. 96. This is hard
Deeply
Mr.
obliged.
We have for
Learned counsel appearing for the petitioner. Stuff. By this application, the petitioner has made a prayer for stay of
My lord, GR case
number
90 of 2025.
pending before the Court of the Judicial Magistrate First Class at Tura. Stop. It is submitted that the charge sheet has been filed in the above case. Stop. However, the same is not made a part of the record. The petitioner shall bring on record the charge sheet submitted in the above GR case number 90 of 2025 by UF an additional affidavit.
Section of 247.
The prayer for interim relief will be considered after the charge sheet is brought into the record of this stuff. Then you say list.
After two, it will
along
come
with the-
together, Your Lordship.
along
It
with
will come
the
together.
sentence. Yes. Meanwhile, it will be open. It will be open to the respondent to file their respective objection against the interim prayer.
So for the state, I'll have the case diary with me.
But then FIR says nothing. Can there be a criminal case based on that?
Let's see, Your Lordship, on
My
the
lord,
file.
lately,
And this is a transaction of a huge amount, not a small amount of 1,000, 2,000, 5,000, 10,000.
It should come, Your Lordship.
We do not know. Let us see what charge.
my lord, the investigation will reveal now that the complainant never gave me 1 rupee also. It is some other person who they say has given. And the charge sheet will also reveal that I never had an account in SBI.
Let us see.
Let me go through the case diary, Your Lordship.
I'm being subjected to abuse, my lord.
Let us see. Let us see. If you are subjected to
My lord.
abuse, definitely this court will interfere.
My lord.
Yes. But then that has to be prima facie borne out.
Nothing can be more prima facie than the FIR itself.
Charge sheet is an addition. It supplements now the allegations. Yes.
Apply, Your Lordship.
Number 5.
Deeply obliged. Deeply obliged. I heartily apologize, my lords, for not being there physically, but I assure my lords next date will be there physically.
Yes.
Deeply obliged.
Lordship, filed,
Yes.
Your Lordship.
Yes.
Filed, Your Lordship.
You filed?
The affidavit.
They have filed the affidavit in opposition, madam.
What is this matter about?
It is a pensionary.
Pension matter, Your Lordship.
It is a pension matter.
Pension matter.
Yes,
Yes,
They filed affidavit.
Yes, my lord. I have received it today, my lord.
is it not? No, on the last occasion.
Yes, Your Lordship was supposed to file on the course of the day, but due to some error, Your Lordship, I have to ask to
See,
send.
make sure if you say something.
Yes, Your Lordship.
Then you do it.
Yes.
It cannot be like that. Just because of your submission, the other side had prayed for time for filing rejoinder, and now you file the affidavit just now. Whereas
Apologize,
before the affidavit, you have passed an order allowing them to file rejoinder.
Yes, Your Lordship.
Now, just because of you are making the court to pass wrong orders.
Yes, Your Lordship.
This is something the council should be. See, otherwise, we will not pass anything basing on your oral submission.
Your Lordship.
The consequence the bar will face. This is something not proper.
Yes, Your Lordship.
It is submitted by MS SR Marak,
Yes, my lord.
Learned Counsel, appearing for the petitioner. That you are respondent number 4.
3, Your Lordship.
Okay. No, you are supposed to file rejoinder against respondent number 4.
Yes, my lord. I'm seeking some time for that to file the rejoinder.
Against the affidavit of respondent number 4.
Yes.
And what about 3?
We will file it together, my lord, with respondent number 3 and number 4. We will file it together.
Which one?
For the state, which they have filed, the state have filed their affidavit in opposition.
You will file the rejoinder today?
Yes.
And
No,
then what
no, my
about-
lord. We will file it together on the next date.
You want to file a rejoinder against the affidavit of respondent number 3 also?
For
Will it be
respondent number
necessary?
3, though, we will. I will just check, and then, if necessary, I will file it, my
We'll
lord.
see to it. Okay. Anyway, just say Ms. E.V. Pasal, Learned Counsel, appearing with the respondent number 3, submits that an affidavit in opposition on behalf of the said respondent has already been filed. Has already been filed. Respondent number 3, yes. Stop. The Learned Counsel for the petitioner prays for grant of some more time for filing a rejoinder to the affidavit in opposition of the respondent number 4. Prayer allowed. How much time?
Maybe, after 3 weeks, my lord.
Prayer allowed. List after 3 weeks. State has already filed the affidavit.
Yes, my lord. They have already filed.
Yes.
Item number 6. Lordship, we have received instructions. We seek at least 2 weeks' time, Lordship, to file an affidavit.
Well, it is a matter where I am before this honorable court just to dispose my representation. My representation was filed 1 year back, where, my lord, I have stated that my juniors, they are getting more salary than me. Now, for disposal of the representation, if affidavit is required, my lord, this may be.
Let us see what comes in their affidavit in opposition.
No, because, my lord, as per the last order, my lord, my learned senior was supposed to take instruction that whether the representation is disposed of or not.
No. It is not that. Instruction, it's the overall instruction. Whether an affidavit is required to be filed or not. Okay.
We have
So
got proper
instruction doesn't mean it is
instructions.
confined only to
That
what you said.
No, but
representation.
what was
Your Lordship.
argued, my lord? What was argued?
No, I
That
don't
is
think
what
I
I'm
made that
saying.
argument.
We go by whatever is said here. It says AG shall obtain necessary instruction before the date.
So we'll
The
file an
necessary instruction
affidavit in 2 weeks'
may
time.
mean many things.
Yes.
It did not say that it's taking instruction with regard to the disposal of that representation. Yes. One prayer made by MST Yangi, Learned AG, appearing for the
2
state
weeks' time.
respondents. How much time? 2 weeks.
2 weeks' time.
2 weeks time is granted for filing affidavit. Can you? This is their basic right. They have to
Well, Lord,
filing affidavit. You cannot stop it, Mr. Day.
We'll take
No,
care
no,
of the
but I-
representation
You do not
also.
expect this kind of objection from a matured counsel like
No, my lord, I'm not objecting. I'm only saying, my lord, only my representation, because what I could have understood in the last occasion,
The
my lord, what I could have understood, my lord, I may be wrong. I'm not saying, my lord, that I'm right. What I'm saying that I was in a position to understand that, my lord, that whether my representation, because it was a long term, my lord, whether it was been disposed or not. That is what, my lord, what I could have understood, my lord. I may be totally wrong, and I have no right to stop them to file an affidavit.
Tell us, can a writ be issued directing
My lord.
department to dispose of the representation?
But my
The
lord,
representation is already been, we'll file an affidavit and explain everything, Your Lordship.
It's all right. It's all right.
Oblige, Your Lordship.
Hearing item number 7.
This is good. Keras file this.
Lord, as per the last order, the matter was listed on the first order. So I had made a submission that I will be filing the written argument in the course of the day. So that I filed.
So it is already there.
It is already
all the written arguments are there. Yes. There is a how many cases are there together?
My lord, there are two matters tied together.
And written argument is filed in
order. My lord, it's a common written argument
for both the
Yes.
It is there. It's on record. Written argument of both the parties.
Your Lordship, I may bring the copy of it so that I can.
It's okay, I can.
Oh, you are not complete. It means you are to address the court. Oh, you have to see what is saying and then only. Okay. Oh, okay. This is a bullet point submitted by
the writ petitioners and the state respondent.
What is the matter about Shangreshwar is here?
My lord, this is
appointment of
regarding
the SSA teacher.
School
Termination.
teacher, my lord, SSA teacher, termination.
There are two different cases.
My lord, one was for release of salary, and subsequently there was a termination order.
Was terminated.
So both can be disposed of by one.
Yes, yes, my lord.
Yes.
Common order.
On the occasion, Mr. Nath said that he doesn't require.
Now, the problem is that you see, we do not know it has been submitted by whom. Okay, advocate for the petitioner. But the name is not there again. Signature says M. Hajong.
Yes.
Is counsel with you.
She's mine.
Yes,
correct. She's mine.
Yes, please supply copy to Mr. Devnath.
We can give no.
Okay.
If you want.
Mr. Devnath's thing is also there, isn't it? Here, this one. Okay, so that is okay. So 5
I don't know what is the
And where is
intention. What is the intention, my lord?
Just a minute. Where is your argument, Mr.
I have filed it, my lord. Probably it is there in the file.
Just see, I think it's there.
I think it is in that file also.
Bearing 1st September 25 in my copy.
No, this one not. This one not.
But if I may assist, I think it is in that file.
These are some copies.
Yes, this one.
It is there. Okay. Okay. It is submitted by the Mr. K.P. Bhattacharya, Lanet State Council. That the written argument on behalf of the state has been submitted. Stop. Mr. Devnath, Lanet Council appearing for the respondent number 527 submits. Mr. Devnath, you have not received copy of the petitioner's argument also?
Yes, Your Lordship.
You have received or not received? Please supply him then.
But we will keep. But I don't know the intention. For his personal satisfaction, we can keep. But the practice is, my lord, we submit a written argument, they go through and they prepare and submit.
See,
we won't have time to
do not drag us to those
So
controversies.
that is a improper practice.
Council, see, the practice is a dignified thing. You see,
That is true.
If
That
you
is why,
think
madam.
that there is something, please take an acknowledgement.
We
it
can
cannot
keep
be-
it. We can keep.
Now you make sure you take an acknowledgement so that this kind of
Providing copy, no problem, my lord.
Mr. R. Devnath,
I'm pointing out the practice here.
Lanet Council paying for the 7 that the copies of the written argument filed on behalf of the petitioner, and the state respondent has have not been supplied to him. Stop. The petitioner and the state respondent
I'll supply.
shall supply a copy of their respective written argument to the learned counsel appearing for the respondent of 5 to 7. We'll just keep it another dates for conclusion of these things. When after a week. 1 week is enough.
Already.
Should be enough for you. See, it shouldn't. Yes. So because
Yes.
see, like
Because already I
the
have
court
given
has basically forgotten everything. We do not know. We may tell senior counsel just to refresh what the thing is again.
That is fine.
Therefore, my lord, if lordship wants some clarification,
you
we can
say
open up.
sometimes-
But he cannot file a written argument over and above a written argument. That is a wrong practice.
He can only reply, respond to your thing. Nothing.
You
else.
say,
That is improper, my lord.
Okay, that is he is respondent. You are the
Yes, yes. That is how they are trying to do.
Anyway, let him see. Let him see.
Yes, he can go through, no problem. We can give, no problem. There
Because
is no
it may
problem.
happen like that you say something which is not a part of record. He may point it out. Okay.
Just apology, just I'm saying. Most of the time, senior counsel, even last time also, he was making some submission, it is not OT1.
Correct.
And today also, you'll see, even if it's considered, he is not giving you copy. I don't have any problem.
See,
Okay.
Lordship,
Already-
Mr. Demnath, please,
see,
please.
already-
This court is not an area for personal building. See, we do not know. That is why right from the beginning, the court told Mr. Senior Counsel that please do not drag us here. You are in a very novel profession. You are not supposed to, you see, like give indulgence to these kind of small things.
But earlier
Okay,
occasion
so
he submitted,
let us-
he did
better
not
you
require
avoid
it.
it. Anyway, just
He did not require a copy, therefore we did not supply. That was his submission in earlier occasion.
Okay. Just what say, as prayed for by the parties, list this matter after a week. For summing up of the respective argument of the parties. Well, just sum up, nothing else. Or maybe, or you may say,
Only the bullet points is required because already I have submitted this written argument.
no, that is okay. We are not saying that you file a written argument. We are just saying that copy may be given to you.
Yes.
And then, okay.
He said he would not file the written argument. That was the last submission.
But then he has given a written notes already.
Already short submission given, you receive in bulky one.
So that is what we will go by that. Perhaps you have that copy, isn't it?
Perhaps we have received.
Yes.
If not received, we will obtain. No problem. Regarding that.
Okay. Yeah. Okay, yes, what is it? As provided for? Yes, if you say summing up, it's all right. Or
yes, or
That's
summing
fine,
up, no problem, man. But they come up with another.
no, then
written
summing
argument.
up doesn't mean that you will open up the argument.
Yes,
again.
exactly.
That is why.
Subject
That is
lordship
why
queries
it's something
only.
like conclusion.
Yes, yes, yes.
So that will use of that word will not be wrong. You senior counsel, just tell us. Okay. Yes. Okay. Please keep this along with all those written arguments. These are all copies. Should be kept together. Should not be one. Shouldn't be here. One should be there. Yes.
Keep your attention.
It will come after 1 week, and then we'll just.
Yes.
17.
Please, Lordship.
Yes.
Lordship, in this matter, will be filing the objection, and I paid for.
In the miss case, isn't it?
In the
Yes,
case,
Okay. Miss cases. What is the number of miss case?
80, I think.
Yes. Okay. You earlier also you have taken time for filing. Is it?
Yes,
Okay.
Lordship.
Oh, okay. That is on the time. When first time. Yes, doctor. Yes, yes. Straight for by.
This is 80, Lordship. 80 of 25.
Yes, straight for MS. Dakhar, Learned Counsel appearing for the respondent number 2. You are
Lordship,
appearing
in
for?
this case, they are respondent
Petitioner,
number.
Your Lordship.
They are in the miscellaneous application. They are respondent number 2.
That is what. That is what we are saying. In the passing order in the miss case only.
Miss case, yes, Lordship.
Number 2. How much time you need?
2 weeks, Your Lordship.
2 weeks time is granted for filing objection. Stop. List accordingly. This is the miss case. And the main criminal petition 47 you just say list after 2 weeks. Just repeat the last order. Respect for the parties, list after 2 weeks. Yes. No more.